Thank you all for being here for Mountain State's Extreme Risk Protection Order or Red Flag Law panel. We do appreciate you being out here today. I have the distinct honor of getting to grill our panelists and play devil's advocate whenever possible, as well as introducing them to you all. So first we have Alexandra Garza, who is a state director for the NRA, the Institute for Legislative Action. She's a product of Colorado schools, got her bachelor's degree from the University of Colorado, and then went to the University of Denver to get her JD as well as her master's degree. She works as the state director for Wyoming, Colorado, and New Mexico, and has a lot of lobbying experience thereof and does a lot of great work for the Second Amendment. We also have with us David Kopel. David Kopel is the research director of the Independence Institute and has a number of titles, which I will go through as quickly as possible. He's an adjunct scholar with the Cato Institute in Washington and is an adjunct professor of constitutional law at the University of Denver as well. He's also vice chair of the Colorado State Advisory Committee to the United States Commission on Civil Rights. David is also a preeminent scholar in Second Amendment, and if you have read any briefs before the Supreme Court or have read any number of articles on the Second Amendment, you have probably seen his name appear more than once. So we are absolutely honored to have both of them here today with us, and we thank you guys both for being here.
Thank you. Pleasure.
And with that, Dave, I think we'll let you kick it off. If you could just go ahead and explain a little bit what the Extreme Risk Protection Order laws are.
Sure, and thank you for having me. I'm excited that MSLF is expanding its reach to the community, and I would say the introduction understated how successful and influential Mountain States has been, because there was a Mountain States Legal Foundation staff attorney back in the olden days who was also a senior fellow and then later a member of the Board of Trustees of the Independence Institute, and that was Gail Norton, who was twice elected Attorney General of Colorado and then served in an outstanding way as Secretary of the Interior under the second President Bush. So the phrase extreme risk protection orders is a conscious misrepresentation. In the bill that passed the Colorado legislature was called Concerning Extreme Risk Protection Orders. And the Colorado Constitution says that all bills have to have a clear title. And there's sometimes litigation of, are there too many subjects in the bill that it's not really clear enough? Or maybe there's something in the bill that doesn't really relate to the title. This is the only bill I've ever seen in watching the state legislature, and my dad was first elected to the state legislature in '64, served 11 terms as a Democratic representative from Denver. This bill is not about extreme risk at all. It's about significant risk. As it says, an extreme risk is a significant risk, which is the opposite. It's a deliberately deceptive title. And if it were limited to extreme risks, it would, in my view, be a lot closer to being constitutional. I think the more accurate term is a gun confiscation order, as I testified to the U.S. Senate Judiciary Committee back in March. It's sort of like the Department of Pre-Crime from the movies, where it's not normally prohibitions on who can possess a gun are based on objective past conduct. You've been convicted of a felony or of a domestic violence misdemeanor, dishonorably discharged from the Army, you're an illegal alien, and on, categories that have, or there's a protective order against you after a hearing based on a domestic violence concerns. This is more predictive of people who are going to misuse guns. I think if they're properly narrow and with appropriate due process protections, they could be constitutional, but the gun confiscation bill that was passed by the legislature goes way beyond that, and based on the record in other states is likely to result in many deprivations of civil rights for innocent people. We know in Connecticut and Indiana, the two states that have had these laws the longest, you have the confiscation order that comes down in an ex parte hearing where the individual has no notice of the hearing, no opportunity to appear, only one side is presented, and then at some point later the individual does get a due process hearing to present his or her side of the story. And when that happens in Indiana and Connecticut, 30% of the time those confiscation orders are overturned. Same thing in Maryland, which enacted a confiscation law a couple of years ago, where about 40% of the orders are overturned. So that tells you there's something very defective in the breadth of how many people are deprived for a period of time of their constitutional rights.
Thank you, Dave. So that brings me to a good point, Alexandra. So Colorado's the 15th state to enact one of these. I actually just got an email before we walked in here that there's one sitting on the governor's desk in Nevada that could be signed as soon as today. But these are relatively new development. I mean, it's only been over the past couple of years that we've really seen this to be a response. Why is that from a policy realm? What's the purpose for that? Why is this the response?
So I think we've seen, as we've evaluated some of the shootings that have happened, there's been a theme of mental health that has appeared. And this has been flagged, no pun intended, as the solution to this mental health issue that we've seen with shootings over the years. Unfortunately, the legislation does not have a mental health component, and it does not address any kind of mental health component. Therefore, we're just sidestepping due process. We're confiscating someone's personal property without truly getting them the help that they need.
So I'd like to drill in on that a little bit. So we always hear it's a mental health problem, but one of the responses to these has been to look to the firearms being used, and in this case, the people using them and who present a risk. So the Colorado bill draws a number of restrictions on who can request an order, how quickly you can then go into court. So for example, an order has to be requested by an immediate family member, somebody that has lived in your house, somebody that you have a close connection with, potentially a law enforcement officer. There has to be some sort of credible threat, and then only then can they have the ex parte hearing, the hearing without the party being challenged. But even then, there's a requirement that within 14 days that party can then go into court. So how are these not all, viable checks on the problem?
Okay. Go ahead, Dave. I know.
The way you described it sounded like it's been described in the media a lot, which is the way the publicity machine of the Michael Bloomberg organization, which runs all this stuff, describes it. But the text of the bill is much broader and worse than that. So in Connecticut, for example, to request one of these orders, you have to have 2 police officers or somebody in the state's attorney's office, what their equivalent of a district attorney's office. And that's an important check because, whoever it is, the police officer or the state's attorney, must have conducted his or her own independent investigation of the facts. They can't just rely on somebody who comes in and says something without doing something to check it out. And I think that's a good procedure, and Colorado should have followed that model. In the Colorado model, there's no check of any law enforcement officer or district attorney looking at this. A very wide range of people can do it, and it's not just the people in your household or close relatives. It is any relative, which by its terms can include a fourth cousin, former dating partners, things like that. It is a situation that is rife for spurned lovers and lots of other people who may have a grudge to seek this order. When they seek this order, they don't have to appear in person before a judge. They can appear merely telephonically, or they don't even have to appear, they can just submit an affidavit. And that deprives the judge who's seeing that of the ability to observe the witness's demeanor, which is a crucial part of due process. To actually see that person live. It's very different, telephone testimony or an affidavit. And then when the person 2 weeks later, after their guns have been confiscated in what could well be a no-knock violent raid at 5 o'clock in the morning, 2 weeks later you finally get your day in court, you still never get your right to cross-examine your accuser. Because according to this bill, this is something I strongly objected to, the complaining witness or anybody else doesn't ever have to appear. they can just submit an affidavit. Well, you can't cross-examine an affidavit. And so that is a procedure calculated to create a large number of false positives and wrongful deprivations of civil rights.
If somebody made a false statement to request an extreme risk protection order or a red flag, wouldn't they still be liable for their statements, though?
Not in any practical sense. I mean, we had some people, law enforcement people who came in and said, well, if anybody did that in my jurisdiction, I'd definitely take action on it. But you can look at the statistics. The number of perjury prosecutions in this state annually is under a dozen. And the number of perjury prosecutions that come out of civil cases is smaller than that. So yes, the person has to sign the affidavit. They do have to say, I could be prosecuted. They sign a form, they recognize that they're subject to prosecution for perjury, because an affidavit is a statement under oath. The risk of prosecution is close to zero. Now, Alec Garnett, the House sponsor of the bill, to his credit, he was a guy who was willing to listen, and he made some improvements in the bill along the way. And one of the things he did was on the House floor, he put in an amendment, which I had suggested, saying there should be a civil remedy so a person who was victimized by a false and malicious accusation can sue the person who did that to them. Now, again, it's the person who's suing who would have to prove that it's false and malicious. Not just a mistake, not just maybe you're a little, too risk averse or whatever, but they'd have to prove falsity and malice. And unfortunately, that got stripped out in the Senate. And the Bloomberg lobby has very much resisted any practical enforcement to deter false and malicious accusations.
Alexandra, what are the policy problems with this? To me, it seems like it's a response to public violence, public shootings. The goal is to cut the head off before something happens. How is this not a good policy solution to something that's happening across the country?
So the main premise of this law requires that a judge merely speculate as to whether somebody will at some point commit a crime. And in the history of mental health and psychology, I don't think we've been able to nail down if somebody is going to become a mass murderer or not. So I'm not sure that our judges are capable of doing such things. The fact that we are allowing a court to intervene with such drastic measures, not because somebody has committed a crime, but because we at some point think that they might commit one based on, evidence that may or may not be true. Because if you're looking at it from that perspective, just the mere possession of a firearm could pose a significant risk, right? If you haven't threatened to do anything with it, just the mere possession of having a firearm in your home could potentially be a significant risk, which is the definition of harm in this bill. And what we're doing is we're taking away an object from someone's home, but we're not addressing the true underlying problem of why that person is maybe reaching out for help. Maybe they're posting something on social media. And the other problem with this is it has an impact on what we do socially. If we don't agree with someone's political stance, can that evidence be used against us in court? It's an ex parte hearing, so the accused or the respondent at this point does not have the ability to know that they're being put up in court and they don't have the ability to defend themselves prior to a no-knock raid that allows their entire house to be searched for firearms.
I want to drill in on a little bit on the evidence that's required in the bill. So I think it's a little bit more than just some sort of circumstantial evidence. Isn't there some sort of requirement that there has to be an actual threat of violence to either themselves or others? So there is a standard there, and we trust judges to evaluate standards all the time. And I also want to look at the argument that, somebody that's willing to lie to take away somebody's firearm is somebody that's willing to lie. I mean, that's the same context that the pro-Second Amendment side uses when it comes to firearms. I mean, criminals are criminals are criminals. If we ban guns, they're still criminals. They don't care about laws. So I just want to explore those two a little bit and the depth of evidence that's required, as well as this idea of, protecting against liars with the law. I think that's a bit of a double-sided coin there.
So the word corroborated in the sentence of corroborated evidence was actually amended out of the bill in the Senate, which we found interesting. Why wouldn't you want corroborated evidence when you have now opened up the petition base to include, anybody you share a child with, anybody you've ever been in an intimate relationship with? That opens up to essentially anybody who is able to file this petition, but the evidence does not have to be corroborated. On that point as well, if the petitioner is law enforcement, they must apply for a search warrant, whether they want to or not. Because there are some circumstances where you may file this, but law enforcement may say, you know what, maybe we just give them an opportunity to surrender their firearms and do it in a very peaceful way, but the law requires that they obtain a search warrant and file and execute that search warrant.
Yeah, one of the dangers of this is it promotes unnecessary confrontations. In Vermont, for example, their law says you have ex parte hearings only when you show there is an imminent and extreme danger. And I would favor an ex parte hearing in that kind of circumstance. But this has, and in general in law, ex parte hearings are disfavored for obvious reasons. And so if you go into federal court and you want a temporary restraining order against somebody, and the judge says, where's the other guy that you want this restraining order against? And you say, well, I didn't tell him about it. He had no notice. The judge is going to say, well, that's kind of unusual, buddy. You got to give me some explanation of why you couldn't serve him with notice of this hearing. Show me some good evidence why you couldn't give him the notice so that this person could appear here. And if you provide the appropriate evidence, the judge will say, okay, that's a good reason. Now I understand why we kind of have to proceed ex parte here, at least on a temporary basis. But there is no such requirement in this law. It's ex parte by default with zero showing of any need. So that's something that encourages abuse. And likewise, as Alexandra was saying, there are other states where they say, okay, it depends on the situation. If you've got some guy who, he's thinking of perpetrating a school shooting and, it's getting towards the end of the school year, we got to take action right away. Well, then, of course, the police should go in with a no-knock if they have to and go and seize those guns right away. And that would be based on the evidence of the facts of the particular case. But the Colorado law just defaults to forcible seizure, to showing up at the person's home with no notice. The first thing the victim of this order gets is the police or sheriff's deputy shows up and say, we're here to take your guns for something you never heard about, you never had any chance to tell your side of the story. Other states have procedures that say you have to surrender your guns within 24 or 48 hours. And you can surrender them. You could give them to a licensed gun dealer, or you could give them to somebody who doesn't live in your house, who could be the custodian of them. And of course, that custodian would have the legal responsibility not to return the guns until the court says it's okay. That's a procedure which is what peace officers in our society are supposed to do, to try to minimize the use of force, to reduce violent, unnecessary confrontations. And that this is part of the reason that so many sheriffs around the state are strongly opposed to this, because instead of the cooperative law enforcement relationship with the public of policing by consent, this turns them more into an army of occupation where they show up and just have to take the person's guns with no opportunity to give that person to peacefully relinquish custody.
Focusing in on that ex parte issue, though, this seems to be securely in the realm of places where we are comfortable with ex parte hearings, or that have been used traditionally and historically for at least a little while. Child protective orders, domestic violence and abuse orders. This seems to fall into that public safety realm. And Obviously, there's a concern that if somebody is a danger to society and you give them 24 to 48 hours, all you've done is put them on a clock for when that they need to execute whatever plan that they were intending on carrying out. How is this any different than just a general public safety concern?
Well, we haven't heard from the states that do have the, allow for the possibility of the peaceable surrender of the firearms. We haven't heard problems from those states about those procedures being implemented. And again, it's a case-by-case thing. The guy who's the ticking time bomb, you don't say 24 hours, but the majority of these are not even for people who are thinking about committing, arguably, a violent crime against someone else. It's more in a case of someone is suicidal, and not necessarily that they're suicidal that moment, but there's more of a continuing risk of that. And so those are the kind of people who, in other states, do seem to cooperate with law enforcement. And in terms of the child, the domestic relations side of this, I think we've seen a lot of the laws passed from the 70s and 80s. You talk to family law practitioners, they will tell you these have been weaponized and quite frequently abused. And all kinds of allegations go back and forth in non-amicable divorces, other situations of family conflict, and the ex parte nature of that substantially aggravates the problem. So I think we've seen the failure of allowing too much ex parte in that context, and we should not repeat the error by extending it.
Alexandra, you've said that this is really a mental health issue that we're dealing with by taking away firearms, but doesn't removing the firearms from a volatile situation give a short period of time for then that person to receive the services or help they need? Doesn't it just act as an interim solution? And what's really the problem with, I mean, they have to appear in person within 14 days. So they have 2 weeks and they can go back and receive their firearms right away. Colorado also has a requirement on how quickly the firearms have to be returned to the person. So even if it is a deprivation of a right, isn't it necessary to allow people to get help that they need? And aren't there built-in safeguards to ensure that it is the most minimal deprivation as possible?
So when you have somebody that is potentially suicidal, and I'll point you to the Connecticut study, that study basically said that after the red flag bill was enacted, suicides by firearm went down 10%. But however, suicides by non-firearms went up by 10%. So yes, we've eliminated an object. What if I plan on killing myself with a toaster? How are you or any law enforcement or judge is supposed to know how I'm going to carry out my suicide? And then try to eliminate all of those objects, that does not solve the problem. There's no requirement for this person to go and get mental health. There's no requirement for this person to be taken in and evaluated. So this is just an easy way to take away property, but the bill makes it almost impossible to get that property back, because then you have to go to court, which this group will probably appreciate, and prove by clear and convincing evidence that you are no longer a danger to yourself or others. So let's think about that for a second. How do we, as a respondent, prove to a court of law that we no longer pose a threat by clear and convincing evidence to ourselves or others? That's a very high burden to meet. And whereas for the extreme risk protection order, the ex parte hearing, it's a preponderance of the evidence. So here we have the petitioner showing up to court, and only a requirement of preponderance of the evidence. You don't hear the other person's side saying, I think their firearm should be taken away. We're not solving the problem.
So Dave, you mentioned that in the other states that have enacted these, there's a 30% return rate. So as soon as they go to court and they vindicate themselves, there's the 30% are then returned. Are they running on the same evidentiary burden? Is it easier? And then if that's the case, that means that the laws are more than 50% successful, presumably. So why is there an issue if only 30% are being found to be no longer a threat?
Well, I think some of the people it is the confiscation is probably appropriate for public safety. It's just you can have better procedures like having the clear and convincing standard, which Colorado requires at the second hearing, the due process hearing, where the complainant has to prove the case by clear and convincing evidence. Why don't you have that standard at the ex parte hearing? I mean, if you're on the, if you're playing a game and nobody's on the other team isn't on the field, you ought to be able to win by a clear and convincing standard, and you're going to have to prove that by clear and convincing 2 weeks later. You ought to be able to do it the first time around. And then, as Alexandra says, if the complainant wins on the second stage, then you have a 364-day order, and the only way you get out of that is proving yourself non-dangerous by clear and convincing, which is a tough standard. The danger, so in a Connecticut case, the only one that's ever gone up to have a reported decision in their Court of Appeals, the guy appealed it by himself. He was pro se. Not a good idea generally. And as the record showed, he had shown up for his due process hearing literally wearing tin foil. So he was probably a guy who was not mentally, was too mentally impaired to be having deadly weapons around. That it's not just a 2-week harm. People say it's a trivial harm. Well, having all your property carted out of your house by the police is a pretty substantial thing to have happen to you. And when that does, that will, it harms one's trust in law enforcement and the system in the long run. So even when that person gets his property back, that kind of person may be less willing to voluntarily interact with law enforcement, to come forward as a witness of a crime, for example, and again, there's more alienation between the public and the government. And it's also true that, for some people, your hunting gun got taken away for 2 weeks, so what? It's not even hunting season. But for other people who live in dangerous neighborhoods, who may be the victim of domestic abuse, they may be deprived of their means of self-defense for a critical period, and this puts them at significant risk.
So we've talked about how you can't necessarily stop a suicide by removing firearms, but we've noticeably kind of avoided the mass shooting and public shooting conversation. How is it not the case that if you remove a more effectual tool in mass shootings, that you're not going to eventually prevent them, or at least prevent one? How is this not the answer? If it's not answering the problem of suicide, maybe there's a different option there, but maybe this is the right answer to public shootings and to mass shootings.
Well, in that case, what is to prevent that individual from going and stealing another firearm?
Well, so it's always access, right? So if you have it in the home, you have ready access to it, then it's a lot simpler. It's easy for someone to pick up their rifle, pick up their AR, and walk out of the house. That's simpler. It's much more difficult to get access to something that you don't already have access to. If you need to, go and steal something from a neighbor, there are barriers there. It makes it more difficult, at least.
I would agree with that point, and this is the difference between suicide and homicide, is in a suicide, you don't have a resisting victim. So, there's very few criminals who kill their victims by hanging them. It's just kind of too complex to get the guy to stand still while you tie the noose and, tell him to stand on a chair. But hanging is a major and nearly as deadly as firearms as a means of suicide, and it's a very common one. Firearms have something unique in terms of crime and self-defense, is their ability to project force from a distance. And that can be used for offense and it can be used for defense. And that's why it's a critical thing for a smaller person to be able to defend herself against maybe several larger, bigger, stronger attackers. So I agree. If you take away firearm or firearms from someone who really is a high-risk potential violent criminal of any type, I mean, not just a mass shooter or something, but also, less crimes that are less famous, less likely to get you on CNN. That's a constructive thing to do, and that's why I support these bills with appropriate due process protections, so that you identify that kind of person and don't make it some tool for the jilted lovers to take revenge.
I want to get back to that in a second, but Alexandra, I'd be interested if you agree with Dave's position there, or are you, it seems to be that you're a little bit more skeptical about the bill generally.
Correct, because if you look at some of the school shootings, Parkland, for example, that individual exhibited plenty of red flags, but nobody did anything about it until, so law enforcement and schools, they had plenty of opportunity to red flag him, but they didn't. So is it really going to help us predict, is a bill like this really going to help us predict when somebody is going to go into a school or a church or whatever it may be and become a murderer?
I think we can flip your example back on you a little bit, though. So in Parkland, we had the prediction, let's say, but maybe they didn't have the mechanism. They didn't have the ability to go in and get the firemen. Maybe that was the problem, because there wasn't one of these bills in place. So if there was a red flag law in place in Florida, maybe that was the mechanism they could have used. Isn't that the answer? So you've got the prediction now. So now we've now created a mechanism for them to actually use the intel that they have, which they've gathered, and then actually effectuate a solution.
So then, in that case, why not have a law, and some states have this already, to charge somebody when they make a threat against a school? Why are we implicating a lot of innocent people under this particular law to capture, possibly hoping to capture, a small percentage of those that may or may not commit a crime? We're seizing property from a lot of innocent people to hopefully thinking that we may make a difference, but we're not attacking the true issues at hand.
And by the way, we have laws, prophylactic laws, against possessing guns if you've been convicted of a felony. Well, the reason the Parkland criminal was allowed to buy a gun in the first place was despite his record of crimes at schools. The Broward County School District was very much following the Obama administration guidance and saying, oh, you commit a crime at school, we don't want to have this school to prison pipeline, as they call it, so you essentially get a get out of jail free card for the crimes you commit at school. Now, I think the spirit behind that Obama guidance was appropriate in some cases. If you have somebody who's illegally distributing alcohol to minors at school, they got somebody to buy some whiskey, and then they gave some whiskey to their friends, and that's a crime. Do you have to prosecute that to the full extent of the law, or can you work on diversion programs and things like that? I think that's appropriate in many cases, but not for somebody like this who had for years been identified by his peers and the teachers as a very dangerous person, highly likely to perpetrate violence against others.
And we will we'll give an opportunity for the audience to ask questions in a little bit, but I do want to pivot to go back to solutions. And I'm going to start with Dave, because I feel like you're going to have fewer solutions. So Dave, how do we fix this? So, let's say we accept the premise generally. What would you be okay with constitutionally on behalf of the pro-Second Amendment community of allowing and potentially getting bipartisan support?
A bill like this with truth in labeling that focuses on extreme risks and has the full range of due process protections, which, if you took the best provisions of laws in various states, and some of the provisions from Colorado is the only law that gives a non-indigent respondent court-appointed counsel. That's a very good idea, and I applaud Representative Garnett for putting that in the bill. If you took the best provisions from the different laws around the country, I think you could come up with a really good model. In fact, I was on a committee created by the National Conference of Commissioners on Uniform State Laws, the Uniform Law Commission, that came together and started working on exactly that process of creating a good national model law. Maybe they wouldn't have agreed with all of my ideas, but that was the forum. They had a wide range of people from across the ideological spectrum, different areas of expertise, and including the anti-gun groups were part of that as well. And we were off to a good start. But the Giffords organization lobbied very hard and successfully to get the uniform commissioners to stop this process, because they would rather have their extremist law. They write it, they get the sponsor, they jam it through legislatures, maybe they get a few amendments here and there, but they get their very extreme and unfair law as their model they want, and were strongly opposed to a more neutral and balanced body coming up with a model law.
So staying there, specifically on due process, because that seems to be the major concern here, how do you fix the due process issue? What would be the solution here? How do we still protect public safety while also affording some sort of due process protection?
Law enforcement has to be the one who brings the petition, and they must have done independent investigation and have corroborated evidence. You do an ex parte hearing only in cases of extreme and imminent danger. The normal process should be for a hearing where both sides get notice, the opportunity to be heard. The respondent has court-appointed counsel. If has court-appointed counsel, has the full opportunity to cross-examine hostile witnesses or whoever's bringing this complaint. And then after if the respondent loses the case, you have a procedure for the peaceable surrender of arms to the extent that that is practical and appropriate on the facts of the case. The order expires after a given time, 6 months or a year, and then if it's going to be renewed, the process has to be done again with an appropriate hearing where the case is again proven by clear and convincing evidence. And a civil remedy to protect against and deter false and malicious accusations.
Alexandra, I have a feeling you don't agree.
I mean, all of those things would essentially be a huge improvement to what the bill is now. I pivot back to, in my conversations with law enforcement when this bill was originally introduced, I really wanted to get a sense of what they were looking at on the ground to have them support such a bill. And what I heard overwhelmingly from law enforcement is that, so in Colorado we have the 72-hour mental hold, right? Which you would have to rise to a risk of imminent danger in order to be held and evaluated for mental health. So what law enforcement has told me is that it's very difficult, one, to meet that standard in some cases that they see on a daily basis, and two, some of the rural hospitals, when they bring the patient in, they don't have the beds, so they're not equipped to deal with anything like that. There's no requirement for a psychological evaluation, so an OBGYN can come in and perform the mental health test. And then they're released because maybe they don't have insurance and that particular hospital does not have any funding or any beds to accommodate them. So that, to me, seemed to be like the true issue at hand. So why don't we fix that part of it? And there was a strike below introduced in the Senate. It was voted down to substitute that particular concept that was vetted through some of the mental health partners and behavioral health industries, to substitute that part instead of this and truly focus on what law enforcement is asking us to focus on, versus just the confiscation of private property.
So is this just an excuse to get at firearms? Is that?
It's any private property. Let's say it wasn't a firearm. Let's say it was your car. Because this is a perfect example. Let's say I'm going to red flag you, Cody, because I think at some point in the near future, I have preponderance of the evidence that you may get into your vehicle and drive drunk. Should I be able to file this, show up to court in an ex parte hearing, and say Cody's car needs to be taken away because I think at some point in the near future, he's going to drive drunk and harm someone? No firearms involved.
And
Green New Deal follow-up bill.
Excellent. I look forward to that.
you'll just have to prove you're going to drive your car
Yeah,
at some point.
right.
And I think with that we can pivot. If anybody in the audience has any questions on of either of our panelists or myself or on the law generally. And I think we have a mic wandering around, so if you put your hand up, one of our mics will make its way to you. Mr. McDonald.
Yes. Both Dave and Alexandra touched on this very briefly, the fact that it seems law enforcement generally opposes this. And I read that there was at least a couple of sheriffs that have actively said that they will refuse to enforce this law. I was wondering if you could talk about that sort of sanctuary county aspect of this issue.
Do you want me to do it?
Well, why don't you start?
happy
No,
to.
Go for it. Go for it.
I think I'm amazed by the Second Amendment sanctuary county movement. I think in Colorado, it's over half of the counties where individuals from their counties showed up in the hundreds and thousands asking their commissioners to withhold resources from enforcing something like this. So to me, the biggest significance of that is, okay, we've got more than half the state, both parties voting at the county level to have these sanctuary cities for the Second Amendment. Why are we voting almost party lines at the state capitol representing the same constituents? So that to me, I can't speak to the legalities of it or how and if it's going to end up in court, but to me, it's the politics that is interesting, is that we have county commissioners, we have people of the state asking for this, but then at the state level, we have legislators who represent those counties who are voting for this bill. So that's probably the biggest takeaway for me when I lobby at the Capitol and, things like that happen. And I don't know if, Dave, you want to?
Yeah, and I don't think you would have seen this degree of county and Commerce City is probably going to do the same thing too, which is.
They did.
Yeah, and that's not exactly a place full of what Bloomberg thinks of as like places that don't have paved roads and there's more cows than people. This wouldn't have happened if we'd had a consensus bill based on strong protection of due process. I mean, I think a lot of sheriffs have concerns just about how vague things are, and it's also this very weird hybrid because a search warrant is a criminal thing, and there are standards for that. And the sheriffs also execute civil orders, a writ of attachment. We had a court case, and A and B are disputing who owns the car, and the court says B owns the car, and so the sheriff will, if necessary, carry out the court order to take that car from B and give it to A. But this is some weird hybrid that it's ostensibly a civil thing, but it sure feels a lot like a criminal thing without the criminal due process protections, because you end up with law enforcement showing up at your house and saying, we're here to confiscate your guns, something you never even found out about. I'd also say I teach constitutional law at DU, and one of the things of the American constitutional structure is we are not like some countries, like France, of a highly centralized, top-down authority. Our Constitution created a strong but not omnipotent federal government and divided sovereignty between the federal government and the states, and left the residual sovereignty with those from whom all sovereignty emanates, namely the people themselves. And so we've had these kinds of conflicts or sanctuaries, from the start with the Kentucky and Virginia resolutions against the Sedition Act's prohibition on criticizing the president, and on and on. And this was part of the anti-slavery movement and different anti-war movements. It's now there's issues on sanctuaries on drug laws, on illegal aliens, on firearms laws, and different people have different ideological preferences among those, but what ties it all together is this concept of the periphery can and does resist what it sees as excessive oppression coming from the center, whether that center is Washington, D.C. or the state capitol.
And I won't make Dave opine on the issue, but I will take off my persistent objector hat for a moment and say that I think one of the interesting things there also is going to be the interplay, if this does go to court, between the sheriff's, perception of their duty to uphold the Constitution versus the legislature's requirements on them. So it'll be an interesting interplay there to see how the Colorado courts treat that, or how other courts treat that as it moves through, which I am sure at some point it'll come up.
In light of what you just said, I'd like to hear a little bit of discussion about where we're at in the legal sense of this being challenged, and what perhaps this organization needs to do more, or what we as individuals need to do more in order to get this very erroneous law, it appears to me, overturned.
So just generally of where we're at the challenge, I mean, obviously we don't expect anyone to speak if there's anything pending. I do think that one of the interesting concerns from that point is standing, and who will actually have the ability to challenge these sorts of things in the courts.
That is certainly a important issue. There is one case that's been brought so far, and who knows if they'll get over the standing barrier. But it is brought by Barry Arrington, who's a very good lawyer, used to be a trustee for the Independence Institute. He was in the Colorado House of Representatives, and he's a specialist in education law, but he's been doing some arms law stuff, and so he's a lawyer I highly respect. Sadly, from my point of view, the client is Rocky Mountain Gun Owners, which is sort of one of the granddaddy of them all among the scam packs on the gun issue, and its founder is a scurrilous character. But with putting that aside, Dudley Brown, Dudley Brown is a sine qua non for Democratic dominance in Colorado. Wouldn't have happened without him. All the money the millionaires and billionaires put in, he was the one who got him over the top in Democratic control of the state legislature. But putting that aside, I think the lawsuit is a very good one. It's based on one issue. The Colorado Constitution says that every bill must be read by title when introduced, and then read at length on 2 separate days. And further, the reading can be dispensed with by unanimous consent. In the Colorado House of Representatives, on, as it's called, second and third reading of the bill, the 2 days the House as a whole debates and votes on the bill, a reading at length was requested and refused. That is an extremely simple and straightforward issue. You don't exactly need a lot of discovery or depositions on that. The transcript of what happened on the floor of the House is all the evidence you need. And the court, a neutral court that does not have ideological opinions one way or the other on the gun issue and just says, I'm going to rule straight up or down, would say, I think have to say, you plainly and flagrantly violated the constitutional procedures for passing a bill. So this can't be a law. Now, of course, if that happened, the legislature could come back, allow for reading at length, if requested, in 2020, and pass it again verbatim. But this 2019 session was procedurally defective, and I think it's a simple and straightforward issue. That doesn't mean you're guaranteed to win in court. And as you say, the standing is a issue of concern.
Do you see any ways to overcome any sort of standing concern? So generally the issue is, in order to have standing in a court, you have to have some sort of articulable injury, something that actually causes some sort of injury to you or your rights as a person. And putting my devil's advocate hat on, unless someone is the subject of an order that is grossly granted without any sort of evidence and then is immediately overturned and there's some issue with their property rights, is there any other way to overcome the standing problem, concern?
I think there are. In some of the other states, We have sometimes filed lawsuits on a vagueness challenge. So it just kind of depends. One of the issues with this bill here is it doesn't come into effect until January 1st. So we're kind of in an interim period right now, waiting on the procedural lawsuit. But we have been discussing different variations.
Dee?
Thank you. Question for David. So I kind of agree with you that if you really had some due process protections, these types of cases might make sense. But I'm trying to think about what are these what is it we're going to help, and who are the kind of people we're concerned about? Because it seems like you have the school shooters, and these are people with chronic mental health problems. And then we've got the cases where, like in my hometown, there were 3 or 4 of these, small town where I'm from, 3 or 4 of these cases in a couple years where wife threatens to divorce the husband, and the husband snaps, kills her, kills the kids, kills himself, and just a horrible situation. And that seems to be a different kind of person. So I'm trying to figure out, and depending on, we have those 2 scenarios, at least in my mind, what's going to happen? So you said that we have this order that's issued, and it's probably valid for 6 months, then it expires, and someone's going to have a burden to come and reintroduce that, probably the petitioner, I think you're suggesting.
Yes.
So I'm just trying to figure out we have, in my mind, these 2 different cases. Is there going to be an obligation on the part of the respondent to undergo mental health counseling, or how is that going to play out in these different cases? What are we going to solve, I guess, is kind of what I'm asking in a long way.
What the most you can ask it to solve is depriving firearms from someone from whom there is an identifiable prior history. You know, the person who has no bad record and then commits a crime, you know, that's not something that these laws even purport to be able to attempt to deal with. And you know, they don't have to be, you know, a good law to reduce crime doesn't have to address every possible type of crime or criminal. It would only help in certain cases. So after this, you know, Virginia Beach crime, the gun ban groups were saying, oh, if only Virginia had a red flag law. Well, this was a guy who passed not only background checks to buy 2 different guns over a long period of time from a store. He went through the National Firearms Act, which is which requires 10-point fingerprints and a process that lasts many months. I mean, it's much tougher than just buying a gun in a store. And he was described by all the people around him as like, oh, he was always smiling at work. So if you're saying you can have a red flag law on that guy, then you're basically saying, well, everyone is too dangerous to own guns and they should have their guns taken away, which is actually sort of what the Feinstein national bill gets towards, because it allows confiscation based on a risk, not a significant risk, not an extreme risk, just a risk. And you will get plenty of social science arguments from the gun ban lobbies that gun ownership per se is simply too dangerous for ordinary Americans. But back to the problem you're solving. So you know, on the other case where you have somebody who has a long-standing sending out signals of danger, that's what a good law could and should deal with.
Mr. Horton?
Yeah, maybe I'd get into a little history here quickly. When the West was won, you wouldn't think of getting on your horse and riding out somewhere, without a pistol on each hip and a rifle in the scabbard. I think we're there again, people. You better look at concealed weapons. I think I like what you guys are trying to do. And by the way, if you're still trying to hire lawyers, I'd recommend you hire both of them. But I think that's where we're getting to, and it's like this last deal killed 11 or 12 of them. Let's assume a third of the people in there had a concealed weapon. He might have killed 1 or 2. I'll guarantee he wouldn't have killed 11 of them.
Well,
and I think that's what we got to do now. Taking all their guns away, you talk about giving confidence to a criminal. Hey, I'm going in there. I know nobody's going to shoot at me because hell, none of them have any guns.
well, one of the things and if the objective were to reduce mass shootings and deaths from them, rather than to use those as a pretext for cracking down on law-abiding people, the solution is very straightforward. the overwhelming majority of these kinds of attacks happen in so-called gun-free zones. And we know at least some of these criminals actually, like a Jew-hating guy with attacks in California, they check things out and they'll say, oh, you know, you want to attack this Jewish site, but they've got security guards there, so you go to a different one. At Virginia Beach, the employees of the city government were forbidden to possess arms at work, even the ones who have concealed carry permits issued by the state of Virginia after fingerprints, safety training, and a background check. Now, Governor Northam, in his special session, says, oh, that wasn't the problem. We want to have a comprehensive ban so that on guns in all municipal buildings, so that in the cities that do say their employees ought to be able to protect themselves, that won't be allowed anymore. That is a formula to have more attacks. The more you say these places, not always, but overwhelmingly, the places targeted are places where the normal people who are there are forbidden from having arms, and they are frequently places that don't even have even one armed security guard.
I think I saw another mic go out.
And you had mentioned early on that about 30 to 40% of some of the cases in these red flag states were overturned before they got very far. But their guns were already taken from them, I'm
Yes.
assuming. How
Yes.
long did it take for them to get those guns back?
There's no data on that I know of, and I think it would probably vary. I think you'd probably have some law enforcement agencies that would be very conscientious and say, okay, the order's gone, you know, come and pick up your guns tomorrow. And others that will say, well, no, we will hold on to them until you sue us and get rid of replevin, and then we'll give them back to you. The Colorado procedures are not perfect, but they lean in the direction of being on the fairer side in terms of return of arms.
Now, follow up maybe. Have there been people who have had a second accusation made, even though they've been overturned on the first one, and somebody's vindictive and says, I'm going to accuse him again?
I can't, not to my knowledge, but you know, a lot of these proceedings are sealed and they're not public records, so it's hard to get data. I'll tell you about one case, not a second thing, but this is from the Santa Barbara Sheriff's Office in California. Man and a woman are married. She finds on his cell phone pictures of his half-naked mistress, so she gets mad and throws a glass of water or some liquid at him. And thereafter, she begins wearing her pistol in a holster inside the house, as is perfectly lawful to do in California. And he goes and gets a red flag on her, and now her guns are confiscated and she's prohibited from owning a firearm.
Question for Alexandra. I'm a lifelong member of the NRA. I'm going to put you in the hot seat here for a second. For 10, 12 years, I've been an NRA instructor, multiple disciplines with firearms. There's a perception out there right now that the NRA is supporting red flag laws. Okay, so my hot seat question for you is, what is the NRA doing to actually get the facts out there and do away with that perception, so to speak? A lot of the community are totally against these red flag laws because they're, you know, they believe they'd be Orwellian thought crimes, you know. So what's the NRA, from your standpoint, doing to counter that?
Well, we keep showing up at all the capitals across the nation and trying to fight these bills. A good example of that is this year, the red flag bill in New Mexico did not make it to the governor's desk. I didn't see, any other gun groups out there. That's my state. I was the one with 500 witnesses battling all 25 bills. Same thing here. Our position was opposed for all these different reasons. We're holding town halls. All of our state associations who are our affiliates. To us, it's very clear that we are opposed to that, but I can't control what others put out on our behalf. So I can only speak to what I do on a daily basis, and I can tell you I've worked my butt off to try to defeat this bill this session, as well as in other states. And that's really the only thing we can do, continue sending out alerts and helping our members and our grassroots members come out and make their voices heard.
A recent transplant from Idaho to Texas. Absolutely appalled at what Texas considers themselves to be a Second Amendment friendly state. I've watched the NRA in Idaho oppose the red flag laws there. Idaho Constitution specifically says firearms cannot be taken away except for felons. Okay, we're still trying to go around that. Now, the perception is out there, and for a lot of people, perception is reality. Sure. At the national level, with your input at the national level, there has to be something out there to get out to the membership about, yes, we are fighting these things. These are the things that we are doing. There has to be that information to get out there to the NRA members, because there's a lot of them out there that are going, wait a minute, they're supporting these red flag laws, and I'm no longer going to support the NRA. It's a possibility to start losing some of the base.
That's good feedback. I appreciate that. I'll take it up the chain. Absolutely.
And she came to speak to us today.
Yeah.
So we're
And I'm on the opposing side.
yeah, she had to deal with me.
Just to be clear.
I will also say, just independent of that, the NRA's ILA website is a very good tool for people who are interested in keeping in touch with what's going through the courts and what's going through legislatures. And they have been monitoring, actually monitored the New Mexico bill through the ILA website. So it is an opportunity for people to see what the NRA is doing there. So I'll shamelessly
Thank you for that, Cody.
plug Alexandra's work there as well.
David, you apparently feel like there are laws that can be written that are acceptable and might have some beneficial effect. But I was wondering, what would, if someone has their guns confiscated, do any of the laws have a provision that prevents them from going right out and buying another gun?
Oh, yeah, not all states, but many of them do, including the Colorado one. Yes, you become your system gets into the national, your name gets into the National Instant Check System under the sort of miscellaneous category of state prohibitors. And one of the things that Representative Garnett was willing to work with was to put in some language, not my ideal language, but to the effect of that once, if an order has expired or been terminated, then that goes out and it no longer acts as a prohibitor on firearms purchases.
David, I'm going to back you up way back to about 40 minutes ago. But when you made statements about the hearing process, you stated a couple of times that the person then had to prove they were, quote, no longer a danger. Along what part of the process was it naturally assumed, because there was an accusation made that that person was indeed a danger?
Things vary from state to state. So in some states, once you've had the hearing where you got to tell your side, and then there's an order against you, that order might continue in perpetuity until you prove your non-dangerousness somehow. The Colorado bill is better written. So you got stage one, ex parte, preponderance of evidence, lowest standard that exists in law. Stage two is then you have a due process hearing, hopefully a couple of weeks later, and then the complainant has to prove the case against you by clear and convincing evidence. Under the Colorado law, that will expire if the court agrees that that burden of proof has been met. Then there's an order against you that expires after 364 days, and unlike in some other states, does not automatically renew. You'd have to go through the process again and prove it by clear and convincing evidence. But let's say on day 14, the court says yes, the complainant in Colorado, the complainant proved it by clear and convincing evidence on day 14, and let's say that maybe this was a suicidal kind of issue, and now it's 200 days later, and you say, that was kind of right. I mean, I was really thinking about suicide. I was having problems. My wife left me. She took all my money and poisoned the dog. But now it's 200 days later. I'm okay. I'm stable. And then, as Alexandra was saying, the only way you get out of that order before day 364 is you have to go into court and prove by clear and convincing your non-riskiness.
Okay, so the initial 2-week trial,
Yeah,
or 2-week
yeah,
hearing is
yeah.
where someone does have to bring substantial evidence to bear.
They have to prove it by clear and convincing evidence, but they get a little boost because their witnesses never have to be cross-examined. They can just testify by affidavit.
Thank you.
Yeah, hi, my name is Mario Acevedo. Thank you very much for your comments here. I was actually one of the guys who went and testified at the Capitol against the red flag law, and it was a very educational process for me. And unfortunately, I've learned some things since then, and one of them has been by looking at the data that red flags don't work. I know that the Every Town for Gun Safety has been going around saying, using the Indiana model as a example as a model, and it's been a complete disaster at preventing gun homicides and gun suicides and suicides all over. And then to your point, I think, would be to the public perception is to get out there more and a counter. And one of the things that I saw, like Moms Demand Action, Every Town for Gun Safety, and Givers, they lie. They lie like crazy, and we have to present the proof and tell the public that one of the things about these gun laws that they really don't protect public safety. Okay, they give the illusion of the, and that's one of the things that I saw the legislators, they go for these things because they're under pressure. You got to do something, so they go for that, and then there's no accountability after the fact when these laws don't work. So I think that's one of the things I would like to see us do more, is be more proactive in showing how these laws don't work at protecting the public.
There is no social science study which finds a statistically significant reduction in homicides or suicides or anything else, bad thing you're trying to reduce as a result of these laws. That is true. Just anecdotally, I listened to a podcast by someone who's a activist on the lobbyist and public affairs person on the vaping issue. And of course, vaping is not perfectly safe, but it's vastly safer than inhaling burning tobacco. But Bloomberg is not just concerned with taking your guns. He does want to run all of your life, not merely the gun aspect of it. Right, your sodas. And on the smoking side of that, they're hugely opposed to vaping. And as she said, it is just amazing how these Bloomberg lobby guys, they just lie so brazenly. I mean, at state legislatures and city councils, truth is not always the highest value, but the brazenness of how much the Bloomberg groups lie about stuff is astonishing, even to people who are experienced in legislative affairs. Yeah.
The March for Our Lives in that, they sent out this a course that I could take from the Johns Hopkins School of Gun Policy and Research, and I've been taking that course. And they had a very interesting little aside there, in that there was a study done in California in 1991 where they wanted to look at risk factors, and it was amazing that they said this, where they found out that law-abiding gun owners are safer than law-abiding non-gun owners. And I've been trying, they just kind of put that in the lecture, and I'm trying to find out why they said that. And it was very interesting because they tend to fudge everything else. But they said that one little thing that to me we should really pounce on.
Well, the Bloomberg School of Public Health, as it is known, I mean, that's its official name, at Johns Hopkins University, has some very capable scholars. And if you actually read their studies, they'll say, okay, it'll get top-lined out as a press release, and the media just reads the press release at best and not the underlying studies. But the interesting thing is when they have the study that says, oh, this kind of gun control is a good idea, you will also see, kind of page like 9 out of 11 of the article is we tested, these various things, and we found, actually no statistically significant benefit from bans on assault weapons or from waiting periods or things like that. And of course, those don't get put in the press release, but actually in their actual data, they find a lot of results about the futility of at least some types of gun laws.
I think we have time for one more, yeah.
Hi, Dave. I'm sorry, I'm a little bit late. So if I'm rehashing some ground that's been covered, please indicate that, and I'll just follow up later.
Yeah.
But one of the things that's most striking about these ERPO assault orders is the complete lack of due process. Now, I'm not an attorney in a room full of attorneys.
We've covered that one in depth.
But I mean, I can never get away with prosecuting violators with this complete lack of due process and hearsay evidence. That seems to be the case in this law. And another very peculiar feature of the Colorado law, which I think is also very dangerous, is the fact that a law enforcement agency can generate these orders sua sponte. And Tony Spurlock, the sheriff of Douglas County, who's the ugly face of this red flag legislation here in Colorado, is of course subject to a recall. There's a movement to recall him. And he has publicly stated that he is essentially trolling the social media comment of people and might well use what people say online as a pretext to issue an ERPO against his political opponents and send his deputies to knock on their door and take their guns or initiate a confrontation. Can you speak about that and the dangers of basically putting people at risk from politically motivated, law enforcement generated ERPOs from a crony sheriff who is likely to get recalled?
Well, I think that the system is at risk of being abused and could be by a particular law enforcement agency. My own view is I disagreed with Sheriff Spurlock on this bill. But I don't worry about him doing something like that, although I will say I come from a highly biased pro-Spurlock position since he has been and is now my client. He was my client in the sheriff's federal civil rights lawsuit against the magazine ban, and he is also, along with 29 other sheriffs, my client in an amicus brief we filed in the Colorado Supreme Court on Monday against the magazine.
So actually, Alexandra, let's take Spurlock out of it. But Dave had previously mentioned that one of the things that he was okay with on the due process side, and Dave, correct me if I mischaracterize your position, was law enforcement could seek these after substantial investigation and if they had some sort of proof. Is that a fair kind of characterization, Dave?
That would be a feeture of a good law, yeah.
Okay. And that was something that you were opposed to, so I'd actually be interested to see what you think about this idea of law enforcement being able to generate red flag.
Well, every law says law enforcement could do it.
Yes.
It's just the question of can other people do it too.
Mm-hmm.
So thank you for bringing that up. Actually, my concern with the law enforcement aspect of this bill is it could actually be used against minorities in an area where law enforcement may not have enough evidence for a probable cause criminal warrant. So we may have an alleged gang member that law enforcement can say, you know what, I'm going to go ahead and file for a red flag order. This gives me the broad authority. It's a lower standard. It gives me the broad authority to come in and seize everything in plain sight, including any firearms. I'm not saying law enforcement does this or is going to do this. I have great faith and love our law enforcement community, but potentially that risk is there. ACLU out of Rhode Island published a 14-page opposition article against these types of laws, and they actually mentioned that in there. So, absolutely, that it's not a good tool in the toolbox.
I think any tool like that is subject to abuse will be abused at some point, guaranteed.
I would imagine. I mean,
so I think that's a good stopping point for us.
I can't predict the future.
I think we're just about out of time. So I did want to thank Alexandra and Dave again. Thank you guys so much for coming out and participating in Mountain State's panel. We really appreciate you guys coming out and doing this. I think it was a great event, and thank you for everybody for attending.